I knew it. I just knew long before we ever got in that courtroom that this case was going to be trouble. And now, here I am in front of the jury, about to make my opening statement. I've got the judge, I've got opposing counsel, I've got my client. Everybody's looking at me, this young, inexperienced, naive attorney, wondering if I can handle this case. Heck, I'm wondering if I can handle this case. And then, of course, there's the jury. There they sat, arms crossed, stone-faced. But you know, it wasn't their composure or their comportment that concerned me. What worried me was whether or not they would understand and agree with the law. Because at the end of the day, if they couldn't understand and agree with the law, my client was going to lose. We had no chance. You see, like a decision maker in a sales situation, juries are susceptible to fear, uncertainty, and doubt. And think about it this way. A jury, 12 people that don't know each other, they're assigned to follow the evidence, connect the dots, and apply law to something that they hardly maybe do once in their life, if that. It's easy for them to get lost. It's easy for them to not be able to make the connection. So it was my job as the advocate to make a connection, particularly because in this case, it was going to be very complex. This was a sexual discrimination case. My client, a nurse, suing the hospital. And discrimination is not easy to prove. And this situation was even more fraught with complexity because it was in Arkansas, central Arkansas in the mid-1980s. Discrimination there has a different connotation than just about any place else. Even though this was a sex discrimination case, when you use the word discrimination, it brings with it certain baggage. It makes it difficult for the juries to connect the pieces. And a trial is really a long chain. And it's always as strong as its weakest link. And in this case, I knew that the concept of discrimination was going to be my weakest link to deal with. And so I took a page out of what I had seen other trial lawyers and some ministers do over the years. And what they do is you have a premise that is difficult to get your head around. You lift the premise out of the situation, the context that you normally talk about it, and you put it somewhere else where it will work, but it's completely out of the context, and you use that to illuminate or explain what happened. So this is what I did. I spoke to the jury in this way in the opening statement. Ladies and gentlemen of the jury, this morning you came to court and you got dressed. You went to the closet and you went to your dressing drawers and you went through the clothing and you discriminated about what you wanted to wear, how you wanted to look. You used criteria like style and fabric and color and weight. And those are all legitimate reasons. In fact, you all did a great job in dressing yourselves. But let me ask you this. What if instead of those criteria, you used this criteria? What if you put the clothing in your mouth? You tasted your shirt or your pants, or God forbid, your socks. That doesn't make any sense, right? That's a criteria it's wrong. It's the wrong way to go. It's the wrong way to discriminate. And so is sex discrimination. Now, I used the courtroom there to illuminate an opportunity for you to make a takeaway. How you can be a better salesperson, a better sales advocate. And today, what we're going to do is use the courtroom to illustrate and illuminate certain persuasive techniques that will make you better as a salesperson.